Advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, welcome back. James.
Yes.
So let me summarize for the people who are just joining us here on WHP 580. This is Carl Rominger. We answered legal questions. You had an incident with the state police. You have a shooting range or an area in your land where you do some safe shooting, and you were confronted by police over a bullet that somebody in a neighboring house claims to have found having bounced off of a roof.
Mm-hmm.
And what happens with the state police then?
They looked at the .45 I was carrying, grudgingly gave it back to me, said something about taking all my firearms and testing them to see if this bullet came from any of them. Now, this was last Sunday, and this hasn't happened, so I'm hoping this is over with. But is it possible that it's not over with yet?
Yeah, it's possible. They would need to get a warrant if you don't want to hand this stuff over.
Yeah, all right. Now, here's my question. I've lived in this house for 40 years, my wife and I. You can imagine the nightmare that would be to have police rummaging around in your house searching for this and that.
Correct.
Okay, I have other guns. I have some old guns that my father had given me. I have some stuff brought back from Germany from the Second World War that my uncle and so forth and so on. Now, this bullet that was supposedly found appeared to be a .380 or a 9mm. Now, could I keep them from gathering up shotguns and .22s and .30 caliber rifles and things like that and dragging this stuff all out and off someplace?
No, because what the police are going to do is they're going to write an affidavit that says, we found a bullet. Bullets come from, in my experience as a police officer after many years, bullets come from guns, Judge. And as a result, we believe that by checking the bullet against the guns owned by the defendant, we may be able to match the two up. And then the magistrate will sign it probably. And unless you got a good magistrate who's really paying attention, and some do, but a lot just sort of leave it up to the police. And so once they seized all your guns, the only thing you could do is go to the court and say, hey, I want all my stuff back. There's no reason for them to seize these items because they're looking for a rifled bullet and of a particular caliber or range of calibers. And what do they need any of my other guns for? But, yeah, I mean, you have that problem.
I think there was a comment made that I'll never see them again.
Well, there's also the comment that the police make a lot of times, like, you're going to go to jail forever, and we're going to put your kids in children's services, so you need to confess.
Yeah.
Or my other favorite one is, we've impounded your car, and if you want to get it out of impound, you're going to have to confess. You know, I like that one. Then we always stick them with the tow bill later when the client comes to see me.
So there's no way of to prevent them from dragging off everything I own?
There's nothing to prevent them from executing a lawful warrant. However, there's nothing to prevent you from suing them later for violating your civil rights, for making the warrant overly broad and excessive when they should have known that they didn't need those things.
Well, if would the warrant say they were looking for a bullet that come from a 9mm or a 380?
No, that's the problem. A warrant just is whatever a judge is willing to sign.
Okay.
And your problem is once the judicial signature is on there, you can't disobey it. They can, lock you down. The detached neutral magistrate. Remember that, folks, when you're voting for district judge. Remember, that's the guy who signs the warrants.
This wasn't the news I wanted to hear.
Yeah, I can't tell you. I mean, I can't give you any better answer than that. All right, my friend?
All right, thank you.
If you
very
need
much.
anything, get a hold of me off the air, and we'll take care of it, okay?
Okay.
All right.
Thank you.
Carl wants me to, the other Carl, atheist Carl, wants me to, I'd like to call him that just for fun. He wants me to finish the story. He's like, would you finish the story you promised us? I had a woman one time, they ran her name, date of birth, and social security number in an advertisement. It was a doctor holding a folder with all this personal data on it. And it ran in some newspapers. And, she was adamant that she wanted to take it to trial and didn't really care if she won a lot of money or a little money. She just wanted to win so that she wasn't bound by a confidentiality agreement, and that for she could go forward and tell the world about how she was wronged by this particular hospital. And to this day, she's free because we won a verdict, a nominal verdict, but a verdict nonetheless, because there wasn't a lot of provable damages. But the jury gave $2,500, which really wasn't a ton of money. We almost got punitives, though. We were really close on the punitives. Cha-ching, cha-ching. But we didn't have enough. We only had 9 jurors. We needed 10 jurors to get the punitives. And the hospital in question is a charitable hospital, so their big defense was, well, don't punish us, even though we did lots of bad things, because we're a charity and you only take away from serving the public. So punishing us is like punishing yourself. It persuaded 3 jurors. That's all the other lawyer needed. He was a very good trial attorney, by the way. So I was hard-pressed there. But nonetheless, she got what she wanted. What she wanted to do was to be able to run around the world and tell everybody about it. And she does that to this day because she did not have to sign any settlements or anything that required her not to speak ill of the other party. Of course, they could speak ill of her, too, but that would probably be hard for them. 540-0580. Let me see here. Shane, I'm going to see if I can get my mom on the phone here.
Is this going to turn into a daily ritual every Saturday?
Not every Saturday, but we got to check on her. This is a good time. This way I can get my son duties done at the same time so I can go smoke cigars. Hello? Hello? That's still ringing. I'm like the old person. Hi, hello?
Did you get her for Mother's Day before she gets on?
Shh. Nothing.
Hello?
Mother, how are you?
Oh, I'm fine. How are you?
Good. What are you up to today? It's Mother's Day tomorrow, so happy Mother's Day.
Well, thank you very much. Oh, I was out doing my job as assessor this morning, and I just got home.
Okay.
So I was busy, and I was going to plant things today because a friend of mine gave me shallots, but it's too cold.
What's the weather like up there in Western New York?
It's wet, damp. We had a call for a tornado.
Yeah.
People got alerts over their phones and stuff, but not last night. And then today it's just turned cold. It was totally foggy. I could barely see where I was going up in Arkwright.
Well, we're having traffic Mageddon down here. Interstate 81 is out right now in a major pass, and there was accidents everywhere else. So the entire midstate is a jam of cars right now, literally.
No kidding.
Yeah.
Wow.
You'll have to look it up on the internet.
I will.
You've got that computer worked out, right? You can use that now?
Yeah.
Okay, good.
Mm-hmm. And I sent you another recipe.
Oh, good. What'd you send us? Can you give me a hint?
Yeah, bishop's bread.
Oh, what's that?
Okay. This is the bread that is a fruit cake, but it's a fruit cake that everybody likes. It's made with chocolate chips, walnuts, dates, dried cranberries, candied cherries, and maraschino cherries.
Okay. By the way, I did get some feedback on your guacamole. A lot of people were making it, and everybody seemed to like it. So
Good. I'm glad. I mean, that's one of my most favorite recipes.
So what I want to ask you was, because a lot of the callers want to know what you think about this Benghazi thing with Barack Obama.
Oh,
You have any thoughts on that?
Just the thought that the truth should come out as to what it is and what really happened there, because our people, whether they be State Department people or soldiers, need to have the most respect and be protected as best as we can do it.
Seems fair.
Yep.
Well,
and that's kind of the whole thing, is that everybody should be treated and kept as safe as they can be, and it doesn't seem to have happened in this instance.
Yeah, I think there's more shoes are going to drop there. It sounds like I'm pretty confident that whole thing was smeared up because right before the election, no one wanted to admit that we were still being assaulted by radical Islamists on 9/11. So just like we pretend the Syrians didn't use any chemical weapons recently, I think that's kind of what the issue is.
Well, that could very well be. So what else is going on in Pennsylvania other than having one huge traffic jam, and unfortunately some people have damaged cars and damaged bodies.
Yeah, and we did have a fatal as well. So it was accidents all over the place, things on fire. I was filled in for Bob Durgan yesterday, and I opined that I thought I was going to die of a biological weapon or a nuclear attack or just good old-fashioned old age, but instead it's going to turn out that I'm going to die sitting in my car in the mid-state, just of old age. Trying to go from A to B.
That could be. I have never seen so much traffic on the thruway. I've had to go to Buffalo a couple times this week, and I can't believe the traffic. It's one truck after another, and the cars are lined up like I've never seen them lined up.
I don't know, and maybe spring has sprung and everybody's going somewhere. I don't know.
I guess.
Well,
I don't know either. Well, listen, are you?
Yeah, you're on the air. Did you know you're on the air, right?
I know I'm on.
All right.
Yes.
All right, Mother.
All right.
All right. Love you. Happy Mother's Day.
Yeah.
We got to go to break. We have to break even with you.
Okay. Bye.
Bye. Oh boy. But she sounded okay, right? I mean, she didn't sound ill or anything, right? Yeah, good. Yeah, I worry about her. She's about 810 years old. Oh boy. I wonder if she even knows I'm really one of her kids or not. All right, Brian, you're on the air.
Yes. At a district justice hearing, who can appear on behalf of a corporation?
Yes, interesting question. Theoretically, a corporation must be represented by a counsel, okay? However, district judge court, there's a rule that allows the corporation to designate a person, or an LLC to designate a person. And if you go to the rules of district judge procedure, there's a rule and a form for it.
Okay, I mean, if it's a major corporation and they send somebody way down the food chain to represent the company.
Yeah, they have to fill out the designation, theoretically.
Okay,
but a major corporation is going to just send a lawyer, and the lawyer can appear on behalf of the corporation. He can't testify for the corporation, but he can appear for the corporation.
Okay, but if you were in that position and they sent some low-level employee there, you could...
If they send anybody but a lawyer, okay,
right,
then they got to have that form, and they got to have it filled out in advance and designate that person.
Okay, a decision that was made, and they had sent somebody like that. The decision was made. Does that nullify the decision?
No. What a district judge does in any civil action is appealable within 30 days of the court of common pleas, what we call de novo, meaning it starts from scratch. So your remedy of any kind of error like that is to file your appeal.
All right. And in general, in litigation, is a corporation required to use outside counsel, or can they use inside?
They can use either or, but the person for appearing in court has to be admitted to the bar of the state they're appearing in.
All right. And if I may, in terms of a civil case, you had mentioned punitive damages earlier.
Yes.
If let's say you're involved in a case and the other side's dragging things out, there's discovery that's gone on for years and years, that in and of itself is escalating. But let's say this thing finally hits trial. Can you then, if you're not represented, if you're pro se, can you make a claim that while you were burning up time running back and forth to the courthouse, that it was preventing you from doing your second job and putting together a case that you were...
You should be moving for sanctions internal to the matter, not at trial. You could, so your damages there, I don't think really any litigation expense, time, etc., is not cognizable in the case, but it is cognizable at sanctions if you have to do excessive work, etc. And actually, good sanction work, you can preclude particular evidence, discovery materials, etc., if they weren't timely provided or there was problems with them, etc. So, but yeah, I don't think you can go to the jury and say, oh yeah, by the way, these guys have been really crappy during the litigation, and here's how they've drug everything out. There is, however, something called delayed damages, so you do get interest back to the time of the event rather than the time of the verdict. So you have the ability to get some additional money. Unfortunately, delayed damages are tied to the actual honest-to-God interest rate, which is like, what, -3 right now.
Correct.
All right, my friend.
All right, thank you.
Thank you. 540-0580. Mike, you're on the air.
Yes, I just have a question about my visitation rights with my daughter.
Okay.
I live in Carlisle. My daughter lives in Castanea outside of Lock Haven. I would like to start having her come down with me for when I visit her instead of going all the way up to Lock Haven all the time to see her. But my daughter's mother told me that that's not going to happen until we get it in a court order that specifically states what time I'm to pick her up and bring her back and where I can and can't have her.
Well, what's so bad about you?
I don't know. I haven't done anything to warrant her to do or say anything like that. I think she's just being hard-nosed about everything.
Right. Well, you can go back for conciliation. You file for a conciliation hearing, and hopefully you can hammer it out in an order you can both live with. And if you can't, then the court can eventually order her to an order you can live with. But it seems. Oh, go ahead.
I just like to have her down with me so she can see my parents, and because she's hardly ever seen them.
Right. And the answer is a lot of times people want to micromanage what the other side does when they have the kid. Mm-hmm. Absent some history of abuse or neglect, or you're living with a Megan's Law offender as a roommate, or your dad's an alcoholic, child molester, one of those sorts of things, then the courts aren't going to micromanage what you do during your visitation times.
Yeah, because there's nothing like that. There's no reason for her to be that hard-nosed about other than the fact that she's a bit of a control freak.
Right. Well, and sometimes in custody matters, and I don't know what the history of the case is, but sometimes we've run into but I've never been away from my kid that long before, which they never actually say, but it becomes a driving force in the custody case. Yeah. And so there's a million reasons why, well, you can have the kid when the moon crosses in Aquarius and you put in paper the hours and the times and the days of the end of the world, because I'm really making all that up because I just don't want to be away from my kid for more than 3 hours.
Yeah.
That sometimes is the issue, too, which I understand. You have a child, so once you have a child, you understand that, but the flip side is if you have a split-parent situation, you have to share.
Yeah.
All right, Mike, if you need some help, let me know.
All right, thank you.
All right, boss. 540-0580. Don, you're on the air. Hey, Don.
Hey, Carl. Thanks for taking my call.
No problem.
Real quick, straightforward custody question. At what age does the court take into consideration the child's wishes as far as where he or she lives?
Well, I mean, what the child's preference is on where to live?
Yes.
Pennsylvania law says that it is one of the factors to be considered amongst the 15 enumerated and one catch-all factor. The well-reasoned, opinion of the child and desire of the child is to be considered and formulated in the best interest analysis. And we don't have a magic age in Pennsylvania. So the older the child is, the more weight a judge often puts on what they say, and the younger they are, the less weight. On the other hand, you can have a very young child who's very articulate or seems to actually have a pretty good grasp of why they want to be where they want to be or how often they want to be. And then you can have an older kid who's very immature and who's very clear to the court or the psychologist, just wants to be at dad's house because dad lets him, snog with his girlfriend.
Now, I'm talking about a 12-year-old.
Yeah, 12-year-old, 12-year-old's going to be listened to. 12-year-old doesn't control. I mean, if 12-year-olds knew what was in their best interest, they wouldn't have parents, right?
Mm-hmm.
So the theory is a 12-year-old's opinion is important. Just as you might go to your 12-year-old and say, listen, buddy, do you want to play soccer this year or swim? You got to pick. You leave that decision to the kid. But you wouldn't leave the decision about, whether to go to school or not to the kid. He just has to go. That's just the way it is. You're the parent, right?
Right.
So same thing with a 12-year-old. You're going to give them some input, but a court's going to have to weigh it against all the other factors in the case. So have you ever known somebody who was in a bad relationship, so they they're in love with a woman who's just a total mess and destroying them, but they keep staying with them, or a guy who's just abusive and the woman won't leave, and you're like, why do they do that?
In my two professions that I've been blessed to be involved in my life, yes, I've seen that quite often.
So here's my point on that. So if we know that adults can want to be with the person who's not necessarily the best one for them, we can also imagine that kids quite often may pick one parent over the other for some reason or another, but they may not be the best parent. So the courts try to intervene in that and try to figure it out. Now, here's the problem. I mean, there aren't right answers, right? There are better answers, and there are sometimes obviously better answers, but how you know which parent's really better and what's really in the best interest of the kid is a crapshoot, with guys with robes basically making decisions based on some things crafted by the law and some experience, a lot of times, which turns out to be, I know another lawyer, and she was complaining recently about a judge who pulled a kid out of school in the middle of the year. And she said, I can't argue with maybe changing the custody around, that, it was a close case one way or the other, but why would you yank the kid out of school in the middle of the year when you're a month from the semester ending and the kid can change it during summer break? Because so most judges will do that. So there's just different tolerances and experiences. So anyhow, wrapping this all back, what I'm trying to say is your 12-year-old, what they have to say is going to be important. To some judges, it'll be more important than others, and some reasons to the 12-year-old will be more important to some other judges than others. And if there's psychologists or custody evaluators involved, then you're going to get even different reads on what the 12-year-old really wants or is saying.
Okay, really basic background is that for 10 years, custody was an equal 50-50 everything. The child lived 1 week with me, 1 week with his mother, 1 week with me, 1 week with his mother. We maintain residence within a mile of each other.
All right, Don, I'm going to make you hold while I go to break, and then we're going to talk about it when we come back.
Okay,
hold on.
Great.
All right, welcome back. Carl Rominger here, 540-0580, answering all your legal questions. Want to remind you, at 4 o'clock, I'm heading over to Harrisburg Beer and Cigar, where we will be smoking cigars and talking about guns and the law. And that's open to the public. It's not a bring-your-own cigar, it's a buy-your-own cigar event. Maybe you can buy me a cigar if you feel like it. I'll probably smoke it. And that's at 3842 Union Deposit Road in Harrisburg. And traffic's not that bad, so get your butt over there. A very informal, fun event. I'm wearing a T-shirt and shorts, so it's nothing fancy. We're just going to talk about the Second Amendment, self-defense, and smoke cigars. You heard the ad for CDL Labor Logistics. They're looking for qualified commercial drivers with clean records. Call 866-293-1880. Those are high-paying positions for clean driver's records, PA, Maryland, New York, New Jersey, and local. 866-293-1880. I know the guy that owns that, and they're really good guys. It's a father and son team that run it. Very professional, very good at what they do, so I highly recommend them to you. 866-293-1880. Also, I'll be at the Lancaster County Women's Expo next weekend, checking things out, and maybe I shouldn't say that. Don, we want to talk about custody still. So the summation was you had a kind of a split custody situation, same school district and all those good things.
Yeah.
What was going on? Then keep going.
Well, we had a custody agreement that was completely 50-50 with, it even stated in our custody agreement that we would not take each other for child support. This worked out great for 10 years. The mother and I remained very good friends until she went to Australia and came back married. When she came back, she had a completely different attitude towards our friendship. And after a very innocuous text message, she filed a PFA order.
Okay.
I was told by my attorney, take whatever deal they offer because this judge doesn't, just doesn't play with PFAs. The judge would not hear anything on custody in the PFA hearing, and all they were offering was supervised visitation, supervised by either one of my sisters or brother-in-laws, which live 2 hours away. And as you can imagine, that has not worked out very well, as they all work weekends, and I've only been able to see my son in the past year 5 times when he's accustomed to living with me half of the time.
Right.
Every time that I have had visitation, he has said, when can I come back to live with you? And I've asked him, be honest, tell me what you want. Do you want to live with mom? Do you want to live with dad? Do you want things the way they were? And he very much wants to go back to the 50-50. I've been very involved in school activities and PTA activities. The problem is for me that she comes from a family with some money,
right,
and is able to afford, a decent attorney. And I'm looking at, going at this pro se.
What county?
Lancaster.
Uh-huh.
So I was wondering, how likely are they to? I don't even know if it's the status quo anymore.
Yeah, well, the status quo with emphasis on the last 6 months and all that good stuff still plays a big role. But here's what I would recommend. I would recommend going to court, and if you can't get what you want right away, get a order allowing for the child to see a counselor, and get the counselor's view on where the kid is at. Because one thing that happens sometimes with kids is you go all through all these steps, and then you get into the courtroom, and I go back with the other lawyer, and the kid's in there with the judge, and they just freeze,
Okay.
And so instead of saying, I want to be with dad or mom, the kid goes, I just want everything to be the way it is. Or, just something very nebulous that doesn't articulate well. Whereas if they've been with a counselor, the counselor writes up a report and says, he really would rather spend some more time with his father, but he's not sure how to break it to his mother because he feels that it would hurt her feelings, and he doesn't want her feelings to be hurt because he still wants to spend a significant period of time with her, da-da-da-da-da. And that way the judge gets it. And we had Arnie Scheinvold here on the show maybe a year ago, and that's available on podcast somewhere. He talks about that, how, they do, a counselor does hours and hours and hours of evaluation. A judge does 20 minutes. So judges will tend to put a lot of weight on what the counselor says because of their frequency of contact and depth of contact with the child.
And that would be at my expense, correct?
Yes.
Okay.
But here's the answer. Sometimes we do construction litigation. A guy comes in and says, I want to sue somebody. And I say, instead of spending $5,000 on attorney fees, let's go spend $1,000 on an engineer and get a report. And then my case is either going to be really easy and really sound, or you're going to know not to spend any money on an attorney.
Right.
And the counselor is a better way than full-fledged litigation. And if she's not agreeable to a counselor, if you go to court and all you say is, I want my kid with a counselor, almost every judge in the world says yes. All right?
Okay.
All right, boss. And I do have a Lancaster office in case you want to sit down and talk with me sometime.
Yeah, where is that located?
It's 1000 North Prince Street, but you got to call in because I'm only there by appointment.
Okay. And consultations are...
well, this is kind of your free consultation, but I'll give you a couple more minutes. Okay, all right, boss.
Gotcha. All right. Hey, thank you.
All right. 540-0580. Kevin, you're on the horn. Hey, Kev.
Oh, you say Kevin?
I did.
Yeah, involuntary commitment.
Yes.
We're at a local hospital. My daughter's 21. Obviously, we have been through this before, only we were on the flip side of it. We tried to get her committed 6 years ago when she was under our custody, which at that age they considered her not under our custody. Anyway,
right.
Now it's the other way. Because of them two high-profile cases here, they automatically won the committer for 5 days.
Mm-hmm.
And we don't think, compared to where we were to where we are today, we have made major progress with just her growing up.
Right.
But she's supposed to start her first job tomorrow, and she did something stupid last night, but we go through this every 3 months now instead of every day. Is there anything we can do? Is there anything she can do? Because she's 21. They just tell us to shut up.
So they're trying. She's entitled to fight any institutionalization through the Mental Health and Procedures Act.
But can she do it from the hospital immediately?
Immediately, I think she's entitled to. There's protocols. So when they first bring her in, they've got to get her a hearing within a certain time period, and I think it's 3 days or thereabouts. And then the protocols from there again are updates thereafter, and I don't know how long or how far apart they're allowed to be. We don't as practicing lawyers too often get involved in those. I was out for one time, and I think we did one years ago as well. But the long and short of it is, usually you want a specialized practitioner, and they do appoint counsel to represent the alleged incompetent. So she should have a voice. But as for doing something right away, I don't think there's anything that can be done right away.
Nothing. They can just see. It's very frustrating because 6 years ago they said just the opposite.
Yeah, they wouldn't take her.
Then she can walk out.
Right, but here they involuntarily commit her.
You do, she's going to go.
They 302 her, and now they don't want to let her out. But she has the right to a pretty prompt hearing. So, but I just don't know the particulars of the case.
Yeah, the only paper they gave me is their treatment no longer than 120 hours, 5 days. She will get a more detailed version of the Department of Welfare regulations in 72 hours.
Right.
So this really means nothing to me. But
right, and that's the first. It's like a 3-day thing, and then it goes up to I think 120 days, but it could be more or less than that, and it has to be the minimum amount. And the psychiatrist or psychologist, I think psychiatrist, will then testify as to what they think is appropriate and what they're looking for to get the person stabilized. And generally, they're really not trying to keep people in these places because the funding's so poor.
Yeah, well, that's the other gripe I have, but that's a different argument. So there's nothing she can do. There's nothing.
Except to go through the Mental Health and Procedures Act. And I think she's entitled to that prompt hearing, but I think that's about it. And maybe an extra...
They'll incarcerate her before that hearing, correct?
Right. They'll pick her up and they'll put her in, and then she's entitled to the hearing. Because we allow for a temporary commitment first on a doctor's signature, but for no more than, I think, 72 hours. And then there has to be a ruling if it's not going to be voluntary.
Okay.
All right?
I guess.
I think that's the right answer, but don't take it to the bank.
Yeah, it's just hard to find other advice on a Saturday. I don't normally call lawyers on the radio.
Well, who does?
You were accessible.
All right. Thank you, sir.
All right, thanks.
All right. 540-0580. See you after the break. Welcome back. Carl Rominger here. 540-0580. Oh, who should I take next? Diane, you've been waiting very patiently. You want to talk about eminent domain.
Oh, good. Thanks for taking my call. Actually, I have two questions. The first one would be about the eminent domain. If I own a property and the neighbor builds some kind of structure that is on over my property line, but how much time has to go by until it's their property then, and until that little bit that their structure is on is theirs?
21 years for adverse possession.
21. Okay. All right. And my second question is that commercial we used to hear where "Get me Rominger on the phone." I never hear it anymore. Is it not ever going to play again?
It is playing again. They stuffed it in earlier today.
Okay. I just didn't hear it.
I don't know if he's keeping it in circulation or not during the week. Are we playing it during the week too? You should put that one in circulation on the. You know that joke. That commercial, by the way, is. R.J. Harris used to do these, and probably still does these impressions of Bob Durgan trying to get me on the phone. Right. So that's actually R.J. on the commercial saying, "Get Rominger on the phone." That's his impression of Bob. So that's R.J.'s impression of Bob Durgan getting me on the phone. So when he has Dan Steele in here in the morning, they'll pop up some rock music, like it's the Durgan, because somehow rock music is associated with the Durgan show. I don't know what's associated with the RJ show. What kind of music you think, Shane? What would you say RJ's music is?
A little bit of classical with some contemporary pop.
Yeah. See, so anyhow, that whole commercial is just kind of a funny joke around here, I guess.
It is funny. I don't hear it often enough, but all right. Well, thank you very much.
Well, thank you. Would you want to ask me something about eminent domain? Was I supposed to tell you something? 21 years. That was it. That's all you wanted to know.
You said 21 years.
Okay. Little piece of advice: if somebody is using your land, but you don't want to have the big dust up and fight over it, you can grant them permission, what's called a license, and you have them sign a written agreement saying you can put your shed over my property line. You have my permission. You include in there.
What's it called?
It's called a license.
A license, okay.
A license. Grant a license. So if I tell you you may fish in my pond, I've granted you a license to fish in my pond, okay? That's the way I would. So but a license is permission. That's all that really means. I've given you the right or permission to do something. Therefore, it's not notorious and adverse because it's with my consent. And so the easiest way to prevent adverse possession is simply to embrace your neighbor and say, I love you and I want you to be here and I agree you can be here, and put it in writing, and that way they can never take possession of the real estate.
Okay.
And it keeps everybody happy, too.
That's if it's before the 21 years. What if it's after then?
After the 21 years, then you're kind of stuck because when you go to kick them off, they may decide that, what do I want to say? They're going to say, 9, it is mine. So what you would want to do at that point is maybe just the clever thing to do is just wait and hopefully the structure falls down or something.
Oh, no. I don't think that's going to happen. Oh, another question. What's a good way to keep kids from climbing on your fence and causing damage? Is it against
electricity?
The law, like to electrocute it? I was going to say, is that against the law?
Electricity, lots of it. It probably is. And unfortunately, what are you going to do? They're going to climb it. I guess you find out who their parents are and report them, call the police. But don't electrify it. No spring guns, no electric fences, no deadfalls, none of the stuff that people used to do to catch the neighbors' kids. All right.
All right, very good. I won't do it.
All right. Oh, she probably has got the 12-volt battery hooked up to that thing. Warren.
Hello.
Hey,
how are you doing today?
Good, brother. How are you?
I'm doing great. I love listening to you talk on the radio, and I love when Bob says call Rominger. I got a question. My wife and I are my daughter moved back home after 14 years of being with her man, okay? And all of a sudden, he doesn't pay no child support. He doesn't do anything. Okay. Now, what are my rights? Can I go after him for child support? For 2 years, I have been paying everything.
So you're paying everything, and the child's living with you?
All 3 of the children live with me and my daughter.
Right.
Okay. And the thing of it is he doesn't work. He doesn't do anything. Okay. And my daughter has this idea that he loves her and he'll come back someday, and all of that. But they're living under my roof. Mm-hmm. I pay all bills. All bills.
I think you can go to your daughter and make her file child support against him. But if she won't, then I guess you could file against the both of them.
Okay. And even though she's living under my roof.
Yeah, that's the problem as I see it.
She collects food stamps,
mm-hmm.
okay, which helps offset the food bills.
I'm surprised they're not making her, as part of that, go get, because she's on a cash assistance, they probably haven't forced her to go for support.
Well, yeah, she's not on any cash assistance of any kind. She just gets food stamps enough to pay for food for the kids and everything. But we pay the electric, everything went up since they moved in. And now it's like, what can I do? Can I go after him, or what can I do?
Yeah, see, I think as long as she's with you, that does create a little conundrum. I'd have to do some research on that one.
Okay.
But I know grandparents can certainly assert custody and act in loco parentis.
Right.
I'd be curious to see whether or not you would have standing, because the kids are living with you. So
Right. I mean, they're on my lease, and everything where I live.
Yeah.
You know, and my rent went up, my electric went up, everything
Warren,
went up.
I'm gonna give you an easy answer. Go to domestic relations and file or ask to file.
Okay.
Against the two of them, and if they say yes, then just go ahead and do it. If they say no, then ask to talk with the domestic relations counsel, who can give you an opinion on why they don't think you can, and then you could talk to a pay lawyer like me after the fact. All right.
You might be getting a phone call.
All right. Good luck.
Okay. Thank you very much.
Carl Rominger here. By the way, 4 o'clock, I'm going to be at Harrisburg Beer and Cigar on Union Deposit. That's over by the Lowe's. So I expect to see every single one of you there. I don't think the traffic should slow you down. Don, I know you had an adverse possession question. I'm sorry, ran out of time. Shoot me an email from romingerlaw.com or hit me on Facebook. Same thing, John. In the meantime, guys, don't forget, go to romingerlaw.com to look us up. We do personal injury, we do criminal cases, we do family law, wills, estates. And, of course, don't forget to become my Facebook friend where you can have all my access to me 24/7 on Facebook because it does come through to my phone when you message me. Talk to you later.